Good morning, everyone. Thank you so much for joining us for today's CLCQ webinar with our presenters from QAI and ADA Law. So we'll be talking about supported decision-making guide resources for a rights-respecting community. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd like to first acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I wish to pay my deep respect to elders past and present and acknowledge that we're on stolen lands and that sovereignty of these lands was never ceded. As today's webinar is being viewed by people throughout Queensland and across Australia, I'd also like to pay my respects to the traditional owners throughout the country and extend a very warm welcome to any First Nations people joining us for today's webinar. Today, I'm really pleased to welcome Mary Burgess, a solicitor at QAI, and Karen Williams, the principal solicitor at ADA Law. And they'll be speaking to us today on their supported decision-making guide. So just a bit about the context of today's session. ADA Law and QAI have recently developed their new resource, the Supported Decision-Making Guide, which gives people and those who are supporting them valuable information that will enable them to keep making decisions about their own lives whenever possible. So in this webinar, Mary and Karen will outline how to make the most of the guide and apply the various pieces of legislation appropriately. I'll hand over to Mary and Karen in just a moment and let them tell you a little bit more about themselves. Before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have that recording available for you to download later this afternoon. The PowerPoints and a link to the guide have been emailed out to everyone who registered as of this morning and are also available to download from our website and from the handout section on the GoToWebinar control panel. We will encourage you to ask questions in our webinar, as we always do. You can simply type your question into the question box on the GoToWebinar control panel, and I'll read your question out for our presenters. We'll hold those questions until the end of the presentation, but feel free to type them in as you think of them. We are also going to run a few polls today, so please keep an eye out for those and pop your answers in when they appear on the screen. So without further ado, I'll now hand over to Mary and Karen to take the presentation away. Thanks so much, Mary and Karen. So we can't hear you. Just make sure that you're on. You're not muted anymore. Looks like our presenters might be having some issues. So, Beck, are you there?
Yes.
Okay, so the sound is working, that's good. So if you're just trying to change your slide, just click on the presentation, just move away from the GoToWebinar control panel. And then you should be able to arrow through your slides.
Can you hear us now?
Yes, I can hear you. You're a bit muffly.
Can you hear us now?
Yes, I can hear you.
But we're a bit muffled, are we?
You've just stopped the presentation. Hello.
Yes, sorry. We're getting there.
No worries.
Okay, can you see the new slide?
Yep, you're good to go.
And you can hear us. Brilliant. Thank you.
Good morning, everyone, and thank you so much for your patience. I'm Karen Williams. I'm Principal Solicitor from ADA Law, which is a community legal centre within ADA Australia, and with me have Mary Burgess, Solicitor from QAI, and between both of these organisations we've put together the guide that Kari spoke about today and that you have the links to. I also wish to acknowledge the traditional owners and the land in which we're meeting today, and acknowledge that we're meeting on all different lands across Queensland and possibly Australia, and pay my respects to elders past and present. The purpose of the guide is to provide some practical help so that people can make their own decisions and have them respected. But also it's trying to demystify the complexity in a world where lots of decisions need to be made, and people are confused and overwhelmed. And John Testerman's introduction there that comes up sums that predicament that people find themselves in quite well. The legislation that we've based this guide on comes from UN conventions on the rights of people with a disability. In Queensland, we have the Human Rights Act, Guardianship Act, Mental Health Act. We're awaiting the final report of the Disability Royal Commission, the NDIS legislation, and also the human rights factors which came to the fore in the Aged Care Royal Commission, which was released quite recently. To sum it up in a nutshell, our Irish colleagues have just implemented their assisted decision-making legislation, and they've put to try and convey what supported decision-making is this acronym ALERT, which is simply ask, listen, explain, and do some reality testing, you know, how might that work, the options that people are considering, and then tell, you know, what is it that your final decision is. So that's just a little helpful way of that they've found to explain what supported decision making is. The reason we need the guide is that we have found in both of our organisations' work that there are some pretty extensive barriers to decision making. And in this slide, this is about system responses to a person, and it's often based on their age or diagnosis rather than the situation or their functional ability. So some of the examples are that a repeated hospital admission can result in capacity being questioned and aged care being recommended, and that decision's taken out of the person's hands. Elder abuse, family violence, when persons older, often the capacity is questioned as a first response. Someone with communication problem difficulties and cognitive or learning difficulties often find the capacity is more likely to be questioned. And Justice Bell, in a lot of his decisions from Victoria, spoke about what he calls protection imperative. So that's what I meant about hardwired protective practices. That we have, as human beings, we're hardwired to want to keep people safe and make decisions for people, not with people, and in accordance with what we consider their best interests. Justice Bell also emphasised capacity as being viewed functionally and based on a general level of knowledge. Like, you don't have to be a specialist or an accountant, etc., to be able to make decisions about your money. And as far as discrimination goes, Justice Bell also cautioned about setting the bar too high for capacity assessments in determining people's abilities, because he viewed this as essential discrimination. And importantly and recently, these themes of Justice Bell's decisions have been imported into Queensland law by the matter of ICO from the Mental Health Court in 2023. So best interests, why not best interests, is actually best described by Justice Brennan as he was then in Marion's case. And basically, he found that the best interest approach relies on the value system of the decision maker and doesn't necessarily require a person to be involved in their own decisions. And Justice Brennan also set out from an ethics framework that the ethicist reported that the opportunity for reasoned analysis and scrutiny is lost. So when the best interest flag is run up the flagpole in the decision-making process, the opportunity for discussion or exploring alternatives is lost because they're seen as second best alternatives and no one wants second best. Okay, and another reason that we found the guide necessary is that the early activation of an enduring power of attorney, or even recognition of informal decision makers as being decision makers when the capacity question hasn't really been resolved. So all these misunderstandings about capacity and general principles to support a person and include people, their views, wishes and preferences lead to premature activation of a substitute decision maker, either through an enduring power of attorney or informally. And then it becomes very difficult to turn this decision-making process around. So this is a preventative way of getting things right from the beginning. And obviously this leads to many more applications for guardianship administration than is actually needed. The safety net is set too broadly, and the people find difficulty in dealing with the complexity. So we've tried to break down a lot of the common decisions in the guide so that people, their supporters, can do step-by-step process through some of the bigger decisions. So I'd now like to hand over to Mary to talk about some of the work of the Disability Royal Commission.
Just before we get Mary to start, I think, Carly, were we going to run a couple of polls?
Yeah, so I'll run those now. So you should see a poll coming up on your screen there. Just if you could select whether you're currently working as a lawyer, a social worker, a health professional, admin or student role, or another role. If you just pop those responses in, that will hopefully help our presenters just understand who's in the room. So I'll give you another 10 seconds. We've had 80% of people vote so far. All right, wonderful. I'm just going to close that poll up and share it back with you. So hopefully you can see that on your screen there. So we've got 42% working as a lawyer, 12% social workers, around 1% health professional, 3% admin or student, and 43% other. And I'll launch the next poll now as well. So how confident are you in applying supported decision making in your work? So a rating scale there. I'll just give you another 15 seconds to pop in your response. Okay, so 5 more seconds. We've almost got everyone voted, which is great. Okay, great. I'm just going to close that poll down now and share those results as well. So, okay, so about 17% very confident, 55% somewhat, 15% neutral, and then sort of got a smaller number of people who are either haven't been exposed or not feeling confident in supported decision-making work at all. All right, hopefully that's helpful to our presenters.
Thanks, Carly. We'll go to Mary now.
Thank you.
Hello, everyone. And I'd like to acknowledge the traditional owners of the land on which we are all today. I'd also like to acknowledge my former colleague, Dane Kingsford, who actually was the QAI employee who contributed to this great resource. So thanks, Dane, if you're listening. I think you're too busy, probably. So this this slide is just describes so fundamentally this issue that Karen raised earlier about as soon as you, in a sense, show signs of weakness or age or difference, someone else wants to step in and tell you how you should be living and what you should be doing. So Mr. Cartwright, who spoke at the Royal Commission, talking about how hard it is because you know for damn sure that if anyone else did whatever he was describing he wanted to do, they wouldn't be controlled or stopped just because the other person didn't like what they were doing. And this is an ongoing and widespread problem, particularly with government agencies really, and service providers. So people who are quite disconnected from the person quite often, but also family members who assume that they know better than the person with disability about what's good for them and the way they should be living or enjoying their lives. And the Royal Commission, they had a lot of these kinds of very stories of great difficulty that people with disability have been having just exercising basic autonomy and agency. And so they were very strongly supportive of supported decision making. And I think the things that we need to, the choice and control, everyone talks about it, but we need to be thinking about how do we make sure that we're making this happen for a person. And choice and control, as I've realised quite recently in one of my matters, it's about choosing to live a smaller life, a narrower life sometimes for people. We don't, everyone doesn't want to experience everything that is on offer. And so what we need to do, instead of deciding, what their best life could be, their best life is the life that people want it to be, with supports to, I suppose, explore how that might be different, but not to have that forced on them. And so there's this, it's really about taking the individual into account every time and not deciding what a great life looks like for a person with disability. And I love the fact that the Royal Commission recognises supported decision making as a fundamental strategy for putting rights into practice. These rights, that are expressed by choice and control and how that happens. And I think we need to also remind ourselves that we can think of plenty of people we know who've made bad decisions, or even just decisions that we wouldn't have made ourselves. But and the person you're thinking of could be you. I know in my life I've made plenty of bad decisions, and if I had my time over, I might make them differently. But what we need to remember is that part of being human and having individual dignity and respect is having the personal autonomy and agency to make those decisions and to live with the consequences of those decisions and learn from them. And the more we do that, and the more we support people with disability and other impairment impacting conditions to do that, the better they become, or we become as we have those experiences in our lives, and they can become at making decisions that work for them. And that's not often the experience of people with disability. Someone wants to step in and protect them or save them from harm. And I'm not advocating for standing back and encouraging people to do things that would cause them harm, but it's not our job to control people. Our job as supporters, family members, service providers, and advocates is to support people with disability, to consider all options and the risks and benefits of each, and encourage them to make the best decisions for themselves, but then to support them in the decisions that they choose to make. And it should always be underpinned by respect for individual autonomy and agency. And with that, the right to the dignity of risk.
Thank you, Mary. And so on to our actual supported decision-making guide. And what Mary's points there are fundamental, and reminds me of some of the key findings of the Aged Care Royal Commission, is that the Commission has found that people receiving aged care valued their autonomy and their own decision making as their highest priority, the ability to continue to make decisions, and priority of carers and family members and service providers were that people were safe. So there were these huge separate views on what was important to people concerned. So that's led us to the guide. So it's meant to be practical. It's unlikely to be used entirely, because it's just each section is just relevant to the area that you're needing to make a decision on it at the time. So if we go into topics, you'll see what I'm talking about. So we've got help at home, NDIS, healthcare, personal wellbeing, finances, and legal matters. So hopefully you won't need to be making all of those decisions simultaneously. So you just need to look at the particular chapter. And as I said before earlier, the idea is to demystify this terminology and the lingo that we tend to use, but the general community is not familiar with. So that's why we have a dictionary, we have contact details, and to give yourself time to explore and just break the decisions down into bite-sized chunks, so that the complexity is not overwhelming, and you don't feel you need to go to a formal process as you wade through. I'll hand over to Mary now to look particularly about access.
So there's a lot in this slide. This particular slide really covers pages 24 to 32 of the guide. And they're all the pages relevant to supporting a person to access the NDIS. But the first and one of the most important points to make here is that a person with disability does not need a formal decision maker to engage with the NDIS. There's no doubt that the introduction of the NDIS has had the effect of driving more guardianship and administration appointments, and that is most regrettable. As you'll see when we discuss our case studies later, in some cases, NDIS service providers are initiating applications for formal decision-making appointments too, and that's also unfortunate. Well, in the cases where they're unnecessary. Sometimes people do need formal supports because there is no one else in their lives willing or able to provide that safety net of some decision-making support that could help get them through. So the guide provides some really simple and useful information, including that anyone can support a person with disability to apply for the NDIS, and that includes friends and family, disability advocate, healthcare providers, including social workers, a person's plan nominee, or a plan manager, or a support coordinator. So all of these people who come into contact with this person, as far as the NDIS is concerned, are able to help that person to lodge an application to participate in the NDIS. Page 25 of the guide provides some really practical advice and information, such as if a person needs help choosing providers and managing their NDIS plan, the NDIA can fund a support coordinator, and the NDIS local area coordinator can help with finding a support coordinator. If a person needs help paying their NDIS service providers, the NDIS can fund a plan manager, or the person can nominate a plan nominee who can manage the plan and the payments for them, or the NDIA can manage the plan for the person. So there's a lot of options there in terms of the ongoing operation of a person's plan, and how that can be managed going forward, that doesn't require a formal appointment of a decision maker. And it's really important for everyone to be clear that the public trustee does not manage a person's NDIS package or their payments to service providers. So if a person needs the NDIS, ultimately these are, and there's concern that they may not be able to manage their financial affairs, the public trustee won't be doing that. Ultimately, either a support coordinator or a plan manager or someone else will ultimately, or the NDIS themselves, will take responsibility for those payments. So that doesn't necessarily solve the problem, but for the person, it strips them of their legal identity before the law. So we need to be clear about what it is we're wanting to achieve for people and how best to achieve that with the least interference with their rights. So if the person's having trouble getting NDIS, the NDIS supports and plan they need, they can get help to review those decisions as well from various other agencies, including Legal Aid Queensland, QAI, and other services. So we run a specific service for reviews and appeals of NDIS plans, which can assist people in these circumstances. It's also important to make the point that by supporting a person to access the NDIS and complete paperwork, it doesn't mean that you're assuming responsibility for that person or the services that they receive. And I think that's part of the reason why people are often a little reluctant to step into this space, because they think, oh, now I'm assuming responsibility. You're not. The person still is, in the eyes of the law, capable of making their own decisions. They are responsible. And any supports they get just help them to live a better life. So you're not stepping in and saying, oh, I'm responsible for this person from this day forward. You're just one of the contacts or part of a support network. It doesn't make you accountable in any way. If you support a person to make connection with the NDIS and engage with a support coordinator, often they can take things from there, provided the person is able to communicate their wishes. And I've seen some great support coordinators who are applying supported decision-making in their dealings with clients and are really empowering people. And protecting them from having their rights and autonomy stripped from them by having a formal decision-making supports appointed. But of course, you've got to, I think you've got to find the right person for the person with disability. So, but the people are out there who can really step in and take this, take these matters forward for people. The guide provides some really useful suggestions about what the person or those supporting them should consider when choosing an NDIS service provider. That's page 27 of the guide. Just prompting the person to think about what things they might need help with, like doing their daily tasks, shopping, etc. It can really help them to begin to develop some ideas about what they need or what additional services and supports they may need if they're looking at a new plan or a plan review. And the guide also makes suggestions about how to make a complaint about an NDIS service provider. And it's very important to be clear that people with disability don't have to accept poor quality services and care. The NDIS is about choice and control. They have the ultimate say about their services and how they like to be treated. It's also important to remember that the NDIS is being paid for by us, the Australian community. We should expect people are delivering quality services for their remuneration. Making a complaint can seem difficult, but it can achieve a number of things. For the client, it can improve services for them, but it also provides feedback to service providers about the quality of their staff and their services on the ground, and it allows them to hold staff accountable for poor work. So don't always assume that a complaint will be met with a negative response. Of course, they should always be framed respectfully and clearly so that a service provider can understand the problem and know what the person wants to have happen to address it. Finally, the guide also has a checklist which can help a person with disability and their supporters to work through the options and supports a person with disability, for a person with disability to make their own decisions and access the NDIS. Remember, a person doesn't have to fully understand or be able to explain how their decisions will be implemented by others. They just need to have the capacity to express what they want or would like to have happen. And just as an example of that, we in our own lives consent to doctors operating on us, go to lawyers who represent us bringing or defending a legal case, and we don't know the nuts and bolts of what they're going to do or how they're going to do it. We give them our instructions, we tell them where we would like things to go or land, and we leave them to do their job as an expert. So, and that doesn't lessen our capacity to provide consent or give instructions. And that's the same with people who need decision-making support. If a person can indicate where they want to live and with whom and what they want to do each week, then they have capacity for those decisions. And as the Disability Law Commission said, exercising choice and control and being independent is sometimes confused with being self-reliant and needing no external support. They're not the same thing. And our duty as advocates and people assisting a person with disability is to support them to exercise their capacity to the greatest extent possible. And we need to be ensuring that we're doing that for our clients, and using this guide will help us to do that better.
Thanks, Mary. We're going to just apply a case scenario now, and Mary will continue to talk to us about case involving conflict of interest and strong family advocacy. So back to you, Mary.
Thank you. So this is Jane. Jane's 52 and she lives with her mother and has an intellectual disability. And she has NDIS supports in place, which her family arranged when the NDIS commenced. Her family's always been very strong advocates for Jane, and they support her right to remain living with her mother and her wish to not try a lot of new activities. She lives with a fairly high level of anxiety, and she likes a fairly quiet life that has some very specific things she likes to do. The support providers believe the family is limiting Jane's choices and controlling her, and they want to move Jane to a shared home with other clients. So they applied to QCAT to have the public guardian appointed for accommodation. And the public guardian was appointed under an interim appointment, and nobody told Jane or her family until after that had happened. QCAT had a hearing, and Jane and her family were represented. QAI assisted them. And her brother explained how the family has always worked with Jane about decision-making, listening to her views and wishes and encouraging her to try things occasionally, but also recognising that she, with her anxiety, she prefers to maintain a pretty limited routine and stay close with the family. So in the end, points were made to the tribunal about a strong family advocating for a person doesn't mean they're controlling the person. There was there's a lot of conflict that can occur when families are doing this kind of, well, being strong for the individual. What we found in Jane's case was that there were certain things about what the service provider, the support workers were doing that she found frustrating and too routinized for her. They liked her to get out of bed really early, like at 8:30 in the morning, and for her that didn't suit. And particularly in winter, she liked to lie in, and they would like her to get up and have a shower, and she found that quite irritating. And they're always trying to get her to go out places, and because of course they were sent with a duty to take her out into the community, and then she would say, I don't feel like doing that today, and there was all this pressure to go because they felt they had an obligation to do it and she didn't want to do it. And in the end, the family stepped in and said, stop it, we don't want to go in. And of course then that gets interpreted as is they're stopping her leaving the house. All sorts of things went on. Sometimes she wouldn't open the door when the providers came because she didn't want them to make her get out of bed and have a shower. And then they would call the police for a welfare check. It caused incredible disruption. So, and it really required some very calm talking. The family were getting agitated. because a lot of the time they were being told what they'd been doing for Jane for 40 years before the NDIS wasn't much good, and very insulting for them, very distressing for them, feeling as though what they'd been doing may not have been right, but also wasn't valued. And so it's really important to understand what's driving a lot of this conflict, but also to put it before the tribunal. If you're in the tribunal on something like this, to really take the time to step out what's gone wrong here. And it's not the family's job to change and buckle and fit in with other with service providers and other people's views on what's good for someone. We had to be very careful about how we took instructions in this matter as well. So we organised with a local NGO to allow us to consult with her, and we made sure we had a member of staff who was in that regional town. They made contact with her. She came in. We got to see her alone without the family, and we could satisfy ourselves that she was making her own decisions and very clear about what she wanted. You can use the guide to do this. The guide can help step through it, but there's also other organisations like ADA Law and 2AI who you can call for some advice here and there on these matters, and we're very happy to assist. We're running out of time, so I will hand on to Karen.
Okay, thank you, Mary. And we might just skip to Lorraine or Lorraine. Lorraine.
Yeah.
And just another quick case study to show how you might use the guide. So in this scenario, Lorraine's 75. She's had some falls at home, and she's not eating and sleeping very well. Her GP thinks it's maybe time to activate the enduring power of attorney, but her attorney, Patrick, is reluctant to step in just yet. He can see that Lorraine's had a bit of knock to her confidence with the falls, and just thinks maybe some extra help at home and reminding about appointments, etc., might be enough. So Lorraine and Patrick arranged for the GP to get a review of Lorraine's mental health through the Older Persons Mental Health Service, and they diagnosed a depression and provided some mental health care. So hopefully that's a short-term condition that's treatable for Lorraine. Also, they identified that probably Lorraine could benefit from some more support, and Lorraine's happy and uses Patrick as a supporter for her to navigate the home care supports and health decisions. The social worker within the Older Persons Mental Health team provides them a link to this guide and prints out the pages relevant to My Aged Care section. And they work through the pages to get a better idea of probably firstly the language, because everyone reduces it to MAC or My Aged Care, and the assessment process and what have you, and so that she knows how to step through and get the supports that she thinks might be helpful to her. So they both realise in this process, Patrick, her attorney, but also acting as her supporter, that Lorraine's able to make her own decisions. She just needs support with accessing the correct information and breaking the decision into smaller steps, giving time to process the information and develop some confidence, and also help time to recover from the depressive episode. So now Lorraine's returning to some of her usual activities, reconnecting with friends and regaining confidence and support to access the service that she needs. So that's just an example of how you might use the guide to access home supports, and just to push back against the attorney perhaps stepping in and taking over as a substitute decision maker, and utilisation of the trusted attorney to be a supporter. So that's the end of the formal presentation, and just back to Carly if there's any questions or
Great, thank you so much. I think, yes, please do put your questions into the question box on the GoToWebinar control panel. And you'll see some links on your screen, as well as I've put the link to the guide into the chat, so you can click on that. I believe there is also a third poll that we were going to run, which is just to check your knowledge and confidence using the guide. So I'll just pop that up on the screen for you to put your responses into, please. So again, another ranking scale from very much to not at all. And we'll wait for those questions to come in as well.
So while we're waiting for some questions, I might throw one out to Karen. So what would happen if the person doesn't want to have the discussion perhaps about their finances? They're a bit private, not feeling comfortable sharing information. What sort of things would you suggest people try?
Well, I'd be saying, is there someone that they trust that they're happy to have that discussion with, someone to bring into the conversation, and or without delving into personal conversation, just ask how would you go about making these decisions? Do you have a formal supporter like an accountant, or someone do your tax return, or do you go to the bank? Or it's just, instead of zeroing in on something that someone finds quite private and distressing and you know, invasive line of questioning, but also work out, you know, is there an issue here? Is there something come to your attention that indicates that finances might be a problem, or you're just doing the same line of questioning for everybody? So, and Mary spoke about this as well. The presumption of capacity means that you presume that people are capable. You don't presume that because X has happened that capacity is an issue. So unless there's a valid trigger, as the lingo used to be about capacity assessments, you don't go there first up. You need some evidence that finances might be an issue, and people are entitled to be private about their finances.
We often see when people are in hospital, don't we, that they have some overdue notices, and that's the trigger. Without the thought about, well, they've sort of been stuck in hospital for 2 months and it's very difficult for them to go through the process of paying bills, which is not to say they're negligent and indifferent. It's just mechanically it's been really challenging for them.
Yeah, so particularly people who are not used to paying bills digitally and they're reliant on their mail, and if they're being away from home, it's very difficult to get the usual prompts that a bill's due. But I've certainly seen clients that have really insistent that the neighbour brings their mail in so that they can attend to their bills, but it's enormously systemically difficult to do that from a hospital setting.
Carly, do we have any questions that have come up as yet?
Yes, we do, and thank you for that, kicking us off there. Just to close up the poll, we did have around 90% of people that agreed that the webinar has increased their understanding and confidence in supported decision-making processes. So that's really positive.
Excellent. And they don't need to feel that they can perfect it the first go. This is very much a learning as you're doing sort of process.
Yeah, it's very practical.
Excellent. So yes, we do have a few questions that have come in, so I might just turn to those. A first one from Gemma, who is wondering how to get that point across to a judge to demonstrate what the client wants in a way that a judge will verify it, or judge, tribunal member, etc. Any tips around that would be helpful.
Well, I think sometimes, I mean, we haven't spent a lot of time on it, so I got a cold. But the general principles within the Guardianship Act or the Powers of Attorney Act actually give you some idea of, you know, how to include people in decision making, and then probably using the checklists as Mary's outlined and saying, you know, what your role was. I gave this person and their supporters this checklist and they worked through it and they've contacted My Aged Care and they've got an ACAD assessment or they've got an assessor with NDIS. So it's just like that practical evidence is the best, most persuasive thing I find, that or that a person doesn't have any debts owing, or, you know, that a person whilst in hospital was able to go to a visit to the post office and pay her bills. And those sorts of things should be quite useful, those practical elements, because capacity is very much should be functionally based and not driven by a diagnosis. That diagnosis is only a clue in this conversation. It's not determinative.
And before an appointment is made, there are a number of matters that have to be, boxes that have to be ticked for the tribunal. So there may be questions about a person's capacity, but that may not necessarily, on its own, that is not the basis for making an appointment. So the person, yeah, there has to be a need. So so if you can show that this person, that there are no decisions that are outstanding that are important in terms of the person's health and safety and well-being, that they can't do with support or haven't already done, you can show that, then there is no basis for an appointment, irrespective of the person's limitations or their capacity, because they have a network of support. They can indicate their views and wishes, or their network knows their views and wishes because of their relationship with the person, their familiarity with them over the years. And that's the way you would put it to the tribunal, I would say.
Yeah, particularly if they have a strong network that's around. People without a network, it's much more often about how did you get to this point? How did you manage this particular challenge? And what are the steps? And we slow them right down and we take it step at a time and understand, oh, so you got it in the mail, right, then what did you do with it? And break their thinking down, because they'll often jump to the end without talking through the steps. So slow that down and then we can assist in explaining that to the tribunal. That's often successful.
And in Jane's case, we didn't, her capacity was not an issue here, but who should be, whether someone should be appointed and who that should be. But we made it very clear that we felt she had capacity to indicate what she wanted in this space.
Yeah.
And we actually stepped out how we engaged with her. And as you were saying, so we actually explained, we organised an interview, we had our independent person there with her, we made sure there was no family about. I asked a series of questions and very carefully recorded what happened. And then we outlined that to the tribunal and said, we feel very confident that she's expressing her own views voluntarily here. So some of, doing that, you might think it's too micro, but actually I think this is the stuff that matters.
Yeah, that's the really key evidence. Is there any other questions, Carly, that we can?
Yeah, absolutely. Thank you for that. So I think you did mention capacity, and there's a good segue into a question from Jeanette. So she's mentioning that the issue for lawyers involves the risk that they are exposed to if they facilitate a client making a decision that has negative implications. The court cases on this do not necessarily give helpful guidance. So the question is, where can lawyers turn to for assistance with assessing capacity?
Well, the Law Council of Australia have recently released Mental Capacity Guide and Elder Financial Abuse Guide, and sort of read together, they provide some sort of high-level tips and oversight, and there's lots of footnotes and cases there that you could turn to. So I'd certainly look there, and in the guide, they stress that that's the responsibility of the lawyer, but also the more you understand capacity and that it's a functional assessment and it's not a medical assessment. It's informed by health and medical practitioners. And often, as lawyers, we can fixate about competent instructions and miss that we're meant to act in clients' best interests. And we also have a duty to the court and to the administration of justice. So it's balancing all of those duties.
Because what often tends to happen is that it's the client who needs the most help gets the least, because they're left high and dry because everyone's sort of fearful of the competent instruction issue. So yeah, definitely I agree with Karen. Have a look at the Law Council's recent guides. They're really useful.
Wonderful, thank you. There have been a couple of questions that have come in, which I'm going to sort of ask as one, and hopefully I've appropriately summarised a couple of the big scenarios that have been provided here. But just wondering, you know, there's some situations that people here are supporting clients with where either the client says they feel indecisive and they're asking for the decision maker to provide advice rather than options. And then another one where I think similarly the client is asking for the advocate to, or for the support person to advocate for them in ways that extend beyond the scope of their role. So do you have any thoughts about how these support people can respond in these kinds of circumstances, and whether the guide is helpful to do that as well?
Yeah, I don't know that the guide is, I mean, certainly start with the guide, but it's sort of advocacy practice, and that might vary from one organisation to another. I am aware that Standards Australia is looking at advocacy practice overall and human rights aspect to that, and so that'll be another big piece of work that will be available to organisations. I think it's important to meet a person several times. So I think Mary's given a really great overview of the length of work to be sure of someone's views and wishes if they are indecisive, and but also point that out to the person. Often, you know, when I'm involved directly, I'll just say, look, it doesn't matter to me, your decision. It doesn't. It's what's important is that it's your decision, and particularly if a tribunal's hearing's likely to be involved, the tribunal member will want to know, you know, why you made the thinking about this way, or you know, you changed your mind or whatever. So sometimes I just let people have time to process that, because explaining, you know, your reasoning to a complete stranger in a tribunal setting is a pretty big deal, and so it's something that needs a bit of time often for someone to process how they'll go about saying, well, you know, this time this was happening and I was worried about this person, you know, and then this happened and I wasn't worried about them, you know, whatever it is. And once again, just let the person know it's not me that, as an advocate, that has to approve of this, but people just want to understand what you're thinking about at the time. Takes the pressure off.
Yeah, I think it can be really difficult. I think with some people who find, with disability, who find it difficult to make a decision, it's often because they haven't, for a large part of their lives, been given the opportunity to make decisions, and they're a little overwhelmed by it, and they're afraid of making a mistake. And I, you know, it sounds very trite to say it, but reminding people that, you know, there's no fail here, and that we all make mistakes, and you know, what you really need to do is weigh up what's best for you at the moment, and there's no guarantee that the outcomes you're hoping will actually be the outcomes. Sometimes we just have to taste it and see. And so for some clients, you know, might be saying, well, it's not locked in, it's not set in stone. You can always, if it's about your NDAS plan, you can always ask for a review if this didn't work. But ultimately, you know, you need to make a decision here, one way or another. If of course you can postpone it, as Karen was saying, and give them more time to think about it, might be better. But otherwise, they can, you know, potentially it's a fear of looking like they weren't up to the decision-making task, and people need to be reminded we all make decisions and make mistakes, and most of the time they're recoverable. So it depends on the risk associated with the decision, I think, is part of something that has to be considered there.
Great, thank you. A couple more, hopefully short questions, and then we'll finish up on today's webinar. I know that we're at time, so people may need to leave, but it'd be great if we can just perhaps turn to these last couple of questions. I think they're a good ones.
And thank you for everyone's patience again for our tech issues. We overcooked our goose, I think. Overly ambitious early.
No problems. So Shelley has asked a specific question here just in relation to circumstances where there is a stay on a decision to impose guardianship order. In those cases, does the person with disability have a right or an opportunity to make supported decisions while the stay applies?
Oh, a stay of a decision, you were saying?
Yeah.
Look, that's probably 2/3 into the story. We'd need a little bit more of where we got to, you know, the sequence of events to be really useful in an answer in there.
Yeah, but just, you know, each day involves thousands of decisions, so it's impossible to not make some basic decisions on a daily basis. Probably, but it still involves that particular decision only. So yeah, it's supported decision making without knowing or needing to know the absolute details. It's just we're just talking generally. When you get into it, you realise that supported decision making is something that we do all day, every day. We ask other people's opinions about what to get for dinner tonight, that sort of thing.
We ask someone's support for them to cook it for us.
And we have to remember that when formal decision makers are appointed, particularly when we're talking the government decision makers, public trustee and public guardian, they are not making day-to-day decisions for clients at all. They're only making the big ones, and the rest of the time people are muddling through making their own decisions with support anyway, without that being recognised by the system.
And I think too, a big thing to remember is a lot of people, you know, talking about the indecision and so forth, even before they had an impairment that was affecting their decision making, they may have always been indecisive and you know, flipping and flopping and getting 16 opinions and then going back to where they started and so forth. So it's also about reflecting on the person's lifestyle, decisions they've made in the past, how they got to this point and so forth.
Great. And Shelley has just clarified her question a little bit, or provided a bit more information about whether the presumption of capacity still applies while the stay is in place.
I think we'd have to.
Yeah.
There isn't a valid order.
Yeah, that would be my position. And you start every day with a presumption of capacity on virtually everything. You know, I know there's a little technicality in there, but on the day-to-day of a person's life, you start with a presumption of capacity.
So I proceed on the basis that there isn't any in-force order at the time.
And formal finding
yes,
at the minute.
Because it's stayed. So otherwise the person is in a complete limbo.
But the stay has no value, right?
Yes, that's right. That's right.
Yeah.
So for the stay to have legal meaning, it means that the order is not in effect.
Yes,
so I think you could proceed on that basis.
Excellent. Hopefully that's been helpful, Shelley. So Mia's just wondering how we can ensure that we get supported decision making included in people's NDIS plans. Do you have any views on that?
Can get funding for supports for that. for people who don't have a network.
And sometimes it's about breaking down the information. So supports would be around financial literacy, for example, and helping people to learn about financial decision making and that type of thing, of which there's some quite good resources around, but it's breaking those big decisions down into money management. So that might be an OT, for example, or attending a group around budgeting, whatever. So it's about starting with the actual decision that the person wants assistance with and demonstrating the support that's required, and then identifying which is the best support out there to provide that support. So once again, it's getting into the nitty-gritty of the actual decision and bringing it down from generally the person needs support to what's the actual decisions that people need support with.
Okay, and the last question here is just actually around working with people from culturally and linguistically diverse communities. So wondering whether, I guess, to reframe the question a little to make it more relevant to the supported decision-making guide, whether and how interpreters might be accessed and used to assist with supported decision-making for people.
Well, supported decision-making is such a broad term, and involves can involve technology like assistive communication devices. It can help with people's sensory deficits, whether it's eyesight or hearing, and it also involves can involve linguistic assistance with interpreters. So the guide could be used with an interpreter. So it's getting the information to the person in a way that they can understand it or appreciate it, as sort of the technical term, and be able to weigh it up. So that support to get the information can be made culturally relevant in a whole realm of activities, and using an interpreter would be one of them.
And the clients can access an interpreter through the telephone interpreter service. It's a national service, and I think agencies need to pay for it, but the individuals who require it don't. Also, I would suggest that Amparo would be a great place to go. Amparo is an NGO that represents the interests of people from CALD communities with disability, and so they have quite a very specialised focus and knowledge, and they do provide training for other NGOs and I think advice for individuals. So I'd be in touch with them. AMPARO.
Excellent. Well, thank you so much. And the person that asked that question agrees that Amparo advocacy is really great. So thanks for sharing that. That is, I think, all the time that we've got for questions today. So thank you so much for your questions, everyone. I think they've been really illuminating and good to hear some of the answers and situations that people are experiencing and thinking about out there. And hopefully the supported decision-making guide will be of assistance to workers in this space and to families as well. So on behalf of CLCQ and our audience, I'd like to again thank Mary Burgess and Karen Williams from QAI and ADA respectively for presenting this session today. We will put the webinar recording up online this afternoon for you all to view. A reminder that you can access the supported decision-making guide from our website, from the where the link is currently sitting, and I'll send that out to everyone this afternoon as well with the recording, and it's also in the chat in this GoToWebinar presentation. So before I do close the session down, just a reminder that there'll be a short feedback survey that will pop up once the webinar is closed. So please take a few moments to fill that in for us, and that's it's very helpful for us to position these webinars and to provide a good program for you. So that's it for now. Thank you again to our presenters and to our audience for joining today. Hope you have a great day, and we'll see you at the next webinar.
Thank you.
Thanks, Carly.